Welcome to Immigration Explained Simply.
Welcome back to Immigration Explained Simply with attorney Aisha Nanyanzi. Aisha is the founder of AKN Immigration based in Gilbert, Arizona, serving clients nationwide and abroad. I'm Evan Mack, and today we're talking about immigration detention and bond. Aisha will go over what detention means, who may or may not be eligible for bond, and what options families should understand when a loved one is being held. Hello, my dear. Welcome back.
Thanks for having me, Evan.
So, Aisha, can you explain what immigration detention is and how someone typically ends up in immigration custody?
So, Evan, the most important thing that I always like to emphasize here is immigration detention is civil, it's not criminal. It's a civil process. And essentially, there are a few ways that someone may end up in immigration custody. It could be that they came in through the border and they presented themselves at the border and sought protection of the US. It could be that they committed a qualifying crime. It could be that they have overstayed their visa. They could have come from a criminal court or criminal jail or criminal detention, and then they were handed over to immigration because they had an ICE detainer on them.
So, when someone is detained, what factors determine whether they may be eligible, for release or even bond?
So when someone is detained, there are a few things that the judges will look at to see whether or not they are eligible for release or whether they are eligible for bond. The number one thing is whether or not they're subject to mandatory detention. Mandatory detention could be because someone committed a crime where they are not bond eligible at all. Um, there's some people who we call arriving aliens. These people are also not bond eligible. Now, if someone is bond eligible, then the judge will look at whether they are a flight risk or whether they are a danger to the community. As far as a danger to the community, they will look at whether they have committed any crimes that would make them a danger to the community, whether they have been arrested for a crime that would make them a danger to the community. And as far as a flight risk, they will look at several factors, including how long have they been in the United States? Do they have any relatives in the United States? Do they have steady income? Do they have steady accommodation? Do they have someone willing to basically, we call them sponsors? And these and so many other factors are considered when the judge is going to look at whether or not these people are a flight risk. And if they are not, or if they do consider them a flight risk, then the judge would basically say, is there an amount of bond that would mitigate this? Now, the lowest amount of bond in immigration is $1,500, and it can go up to, tens of thousands. And is there an amount that would satisfy the government that if this person pays this much bond, they will come back to immigration court and basically seek their relief or see their case through?
So who is not eligible for bond? What kind of circumstances or legal categories tend to result in mandatory detention?
There are people who have committed some crimes that we do call aggravated felonies. So those people may not be eligible for bond, or they are not eligible for bond. And again, just because a crime is a felony, for for your state conviction or whatever crime you committed does not necessarily mean that it's an aggravated felony for immigration purposes. Basically, we could look at it totally different. And just because a crime is a misdemeanor in your state does not mean it is not an aggravated felony for immigration purposes. There was, you've probably heard of the Leck and Riley Act. Those were available where they listed a few of other crimes that would make people subject to mandatory detention. I did also say people who arrived at the border or sometimes even at the airport and they were brought in as arriving aliens. If those people would not be basically bond eligible. And it doesn't mean they've committed any crime. It's just the way they were paroled into the US and they were designated arriving aliens. That is the only thing that would make them ineligible for bond. Now, one important thing to note here even is regardless, ICE has a lot of discretion to release these people under parole. They can just release them whether or not they're bond eligible. But as far as bond, where they have to go before an immigration judge and request for bond, that would basically make them bond ineligible.
Mm. So, Aisha, for families unfamiliar with this process, what does an immigration bond hearing generally involved, and what role does an immigration judge play?
So an immigration bond hearing is pretty short. Um, Honestly, sometimes it's about 15 to 30 minutes, I want to say. Most judges will have all the paperwork in front of them. They'll have the sponsor documentation, maybe the client's application for relief. They will look at documentation regarding, say, their employment, if we are trying any information that we submit to show that they are not a flight risk. And the judge will look at the documentation. In most cases, they will ask the respondent or the person seeking bond, their attorney, if they have one, to basically give a brief. And then the government attorney, which is the Department of Homeland Security, will also give a brief argument on why they think this person is ineligible for bond. And the judge will make the decision. Oftentimes, the judge or the department may insist that the person seeking bond testify, but sometimes we just throw in a statement from the client addressing all these issues, and the bond case is pretty short, but a lot of the work is in the paperwork that we have to submit and the briefs that we have to submit to show that this person is eligible for bond.
Mm. How does the timing of detention, such as when someone is detained during a case, affect their options for bond or release?
So the timing of detention always is, really matters, because essentially when someone is detained, right? The government, if they haven't already, so if they were in court already, if they were before the immigration court, they already had a notice to appear. But if they were not in immigration court before, maybe they had an affirmative case or they didn't have a case at all, pending before immigration, then they will issue them a notice to appear. And once they're issued a notice to appear, which will basically state why they are being held and their nationality, and basically will state a bunch of things that we have to concede or deny, then we can file a bond. Now, there are some what we call pre-NTA bonds, the ones that you file before someone is issued a notice to appear. But the point is, when you're detained, your case moves really fast. Cases of people who are detained in immigration move faster than the cases of people who are not detained. So if you file for a bond, um, you could be released before your removal case. But assuming you file for a bond later on and you've already had your merits hearing, which is your final hearing, and you have a removal order now, or the judge has denied your case, maybe you're appealing, it starts to become a little bit tricky for even the judge to want to release you, because if you have a final removal order, right, then you probably don't have a lot of motivation to come back to immigration court. And then they will say, oh, you don't have any relief. The judge has already denied your case. So how sure are we that you're going to come back to court? So the timing, the sooner you can do it. Now, sometimes, again, we tell people not too soon, right? Because when you file, you have to show, hey, I'm going to come back. I have a strong case. Look at this case that I filed before the judge. So I'm going to come back. My case is really strong. And the judge may look at that and say, yeah, this is a strong case. This person is very likely to come back. And yeah, so the timing is really important when it comes to these cases.
So in some situations, people remain detained for long periods of time. What does that prolonged immigration detention look like in practice? In for people that don't know, why does it happen?
So for people that don't know, what that looks like is, so we talked about people really who are subject to mandatory detention, right? So
Right.
they're going to be detained throughout their case. So whether or not they are granted relief, they are going to be detained. Now, of course, there are situations where you can come in and file a habeas and say, okay, this person, yeah, we need to revisit this, right? We need to revisit why they're still detained. There are people who are detained because they were granted, say, withholding of removal or withholding of removal under the Convention Against Torture. And basically, these are people who have removal orders, but the judge has said, yes, I'm ordering them removed, but you cannot remove them to their home countries because they will be persecuted in their home countries. And the situations could be because they've missed a 1 year filing asylum deadline, or because they did not use CBP1. They did not have an exception to the CLP. So there are so many reasons. It doesn't necessarily mean that they were ordered removed because their cases were weak, but there is some law that would basically make them ineligible, say, for asylum. So in situations like that, the government or the department is going to try and remove these people to another country, not their home country, because the judge has said they cannot be removed to their home country. So they will try. And if they cannot show that there is a country willing to accept this person, or they try for a long period of time and they still cannot have this person removed to a country and that the judge did not say they cannot remove them to, then we can start looking at options. Do we need to go to a district court judge and file a habeas and tell the judge that it has been 6 months? This person was ordered removed, yes, but the government has failed to remove this person, and you cannot have him basically you cannot have him held indefinitely. He cannot be detained indefinitely. So you now need to release him. Or someone was previously detained, they were released under the order of supervision, and then the government, without justification, held them again and detained them again. So those are really situations where we start to look at other options, because these people, if you've been ordered removed, then you may not necessarily be eligible for bond, right? But we can ask a district court judge to tell the government to release you.
So, but Aisha, when someone is subject to prolonged detention, what legal options may still exist to challenge continued custody or even seek that release?
And so if someone is subject to prolonged detention, there are again a few things that we would look at. So say someone was previously was bond eligible. They previously requested for bond and the judge denied it because maybe they thought they were flight risk or they thought they were a danger to a community. So maybe at the point that this person had their bond hearing, okay, they had committed a crime or they had been arrested for a crime, and the case was pending in criminal court. So the judge says, you're a danger to the community. Now, a few months down the road, this person fights the crime, or maybe the prosecution drops the charge and the case is dismissed, or maybe this person is found not guilty. So many things. Now we can go back to the judge and say, oh, hey, look, there is changed circumstances. You previously denied this person bond because you say that they were a danger to the community. But look, the prosecution has dropped this charge because for whatever reason, maybe they could not prosecute this person. Maybe they did not have the evidence. So how can you say someone is a danger to the community when the prosecution could not even meet their burden to show that this person committed their crime? It could be maybe you said previously that this person was a flight risk, but we probably before that we couldn't find maybe their employer or they were on vacation. So when you had the bond, we didn't have the letter to show that they had steady income, but there was a changed circumstance here. So it comes down to the changed circumstances. It comes down to information that was not available before when you had the first bond hearing. So you go back to the judge and you tell them, we have this new information. Would you be willing to reconsider your decision? Of course, you have another hearing, and the judge could rule either way, right? Um, sometimes it's changed laws. There has been a lot of circuit decision regarding whether or not people who entered without inspection were bond eligible or not. And over the last few months, there has been a lot of cases from district courts and circuit courts that are saying, yes, they are, no, they are not, yes, they are. And between all those cases, you go back to the judge and you say, the circuit court has said that my client is bond eligible. Now we need to do another bond hearing, and then they reconsider, they look at the evidence again and they look at the new law again. So yeah, and sometimes we just have to go the habeas route that I talked about before, where we
Yeah.
just go to the district court and ask the district court judge to have the client released.
So without getting into too many details, can you share a situation where a detained individual or their family, felt stuck, and how understanding bond eligibility or detention options help move their case forward?
That's a tricky one because we do a lot of bond cases. So I'm really trying to think about one. Um, Really, I think I will talk about a young client of ours who was in school, was in college, got into a fight, and essentially they were arrested and then they were again detained,
Wow.
handed over to immigration. And we went ahead, filed the application for relief, and while, you know, right before the bond hearing, the prosecution dropped the charges. And we went to the judge and we said the charges have been dropped. And of course, we had the government argue they're going to refile them. And we had to make a case to the judge that what we do have right now is that these charges have been dropped and we cannot hold this young client of ours indefinitely just because we have to wait for the state to refile the charges. And the judge agreed with us, and the our client was released. They paid the bond amount and they released them, and they went back home to their family. But it was a traumatic situation for our client. They had been in the country since they were 3 years old, and they had never been arrested. Even when they were arrested for the trouble they got in at school, they just took them to the police and then handed over to ICE. So being in detention was really challenging for them, and it was really tricky for them. And it was heartwarming when they were released and they went back to their family.
That's good. Before we close things out, to Aisha, what does the early timeline of detention case actually look like, and where do bond decisions typically fit into that sequence?
So the early timeline of detention cases, again, typically it really depends on where you were at. Why you detained right at the border when you presented yourself, and by the border I mean both, the land border, the airport, or why you detained while you had a case pending with USCIS and now you were sent to immigration court, or were you just detained with nothing pending at all and you were sent to immigration court? So then the timeline starts playing, because if someone already has a case pending before USCIS and we already know that they have relief pending, and maybe now they're going to have to basically fight their case in immigration court, we can almost always file for bond pretty fast as long as we have everything else we need. But for someone who has no case pending at all, now we have to work on showing, are they eligible for any relief? And
Mhm.
if they are eligible for any relief, maybe we need to file it, because we need to show the judge. It's not just a matter of showing they're not a flight risk, they're not, a danger to the community. And when the judge is evaluating whether or not someone is a flight risk, whether or not this person has an application for relief is very important in the judge's evaluation. So that is something that we need to look at as well. So the timing depends on whether or not you have something pending. When were you arrested? How long have you been here? Those are all factors that we look at to determine whether we want to file for the bond, whether we want to file for the bond immediately. And of course, if you were arrested for a crime and that's how you ended up in immigration detention, whether you're eligible for bond at all.
Oh, wow. Ms. Aisha, information. Thank you for your time.
Well, thanks for having me, Evan.
That brings us to the end of today's episode of Immigration Explained Simply. If you or a family member has questions about immigration detention, bond eligibility, or related immigration matters, you can visit aknimmigration.com to learn more or schedule a consultation with Ms. Aisha Nanyanzi and the team at AKN Immigration. Thanks for listening, and don't forget to subscribe, share, and leave a review if you found this episode helpful. Thank you so much, and we will see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.